Thank you so much for joining in, Pierre. This is Triumvir Law's International Law and Arbitration podcast. The idea was to basically start a dialogue in relation to international law and arbitration in India and the Asian subcontinent, and for practitioners and students alike, right? So in that context, we have formulated an entire series with about 8 practitioners from across the world. And we're delighted to have, Pierre joined for this session. Just to introduce Pierre, I can possibly go on for 15 minutes, but then we possibly do have some sort of paucity of time in terms of that. But I would like to keep that short and simple, and I hope Pierre would not mind in relation to that.
Of course not.
So, Pierre is a professor of international law in University of Louvain and a visiting professor at University of Leiden and Melbourne. He's also a special counsel in Foley Hoag, and he's served in various positions at the ICJ, and he currently represents, sovereign clients before the International Court of Justice, the International Tribunal of Law of Seas, and various other domestic and international tribunals. His expertise is sought after by governments, international organizations, and private entities alike, and we're just truly delighted, to have you on board here, right? So, before we begin, Pierre, I just want to understand that what was your early inspiration into law as such? Because in India, or maybe the Asian subcontinent, very truly speaking, the two alternatives are being a doctor or being an engineer, which is a software engineer. So law has come up in the last decade or so, right, as a career option, which makes some sense, right? So what was your early inspirations into this?
Well, thank you very much first for the invitation. I'm very pleased to be with you, and I'm thankful for the invitation and your very kind introduction. I'm the first lawyer in my family, and the reason why I studied law was maybe, as many students, by eliminating other options. That's the beginning maybe for many law students. I was intending to study philosophy at university, and then as a good boy, listening to my mom, and the Belgians are very practical people. They say, my mother turned to me and said, "My son, what are you going to do with philosophy? Is that a trade? Can you do something with philosophy?" And I got the point, and then I decided to study both a law degree and a philosophy degree together at the University of Louvain. Passing my law exams in June and the philosophy exam as resit exams in September. I started studying law without any special interest for international law. Of course, I was very much interested in international affairs, reading the newspaper daily, and being also interested by international politics. And I'm talking I started my law studies in 1985. So that's a long time ago, after graduating from law school. And it was a very different world. And I ended my law studies. Law is 5 years in Belgium, 3 years of bachelor degree and 3 years of master's degree. And at the end of my master's degree, it was basically the end of the Cold War, the collapse of the Soviet Union. And the world was very rapidly changing. And the international legal system and legal order was very much in need of reconstruction, the system itself. And so philosophically, it was a very interesting moment. And I think the reason why I decided to specialize in public international law, probably because of a professor. Very often you get interested in a subfield of law because you are inspired by a teacher. And my teacher, who later became my mentor for my PhD, was Professor Joe Verhoeven. And I really found his courses fascinating, his approach to the law, to international law, really interesting. And that's how I got hooked into law and into international. But at the beginning of my career, and this is something I think, of course, every professional career is different, and I've been in the field for 30 years now since I graduated. I think, it's the process of learning is never ending. I started my career after law studies. After graduating law and philosophy at Louvain, I went to Cambridge to read the LLM and then came back. And then I started practicing. And I started practicing in a Belgian law firm, a very reputable Belgian law firm, but still a small Belgian law firm compared to the rest of the big law firms of today. And I did torts. I worked on all sorts of accidents, car accidents, medical accidents, plane accidents, you name them. And I did insurance law, contract law, reparation, all that stuff, working for a very well-known practitioner who was teaching torts at Louvain University. And I learned so much. But I began as a domestic lawyer. And then I had the opportunity to become a teaching and research assistant part-time at the university, and then full-time, and then I embarked on my PhD, etc., etc. But I think maybe one element to keep in mind for the young professionals is that, what is important in a career is to be able to. You don't know what possibilities, what professional opportunities will come up in 10 years, 5 years, 20 years from now. What is very important, I think, to keep in mind is that you must be good at what you do while you are doing it and do the best you can while you are doing it. And opportunities will happen. And the question is, will you have put yourself in a situation where you can pretend to benefit from the opportunity? Maybe you will not, be successful in having that opportunity and in applying and getting the job, etc. But at least you must put yourself in a position where it is reasonable to try to have that next opportunity in your professional life. And I think, a professional life is built incrementally from one step to another. And of course, it's difficult at the beginning to predict everything it's impossible to predict everything that will happen. You just give a general direction and you hope that opportunities will arise, that you will be up to the challenge when they arise. And that's it. I mean, and I must say also, I've been extremely lucky in a way. I as I said, I finished my studies at the time of the end of the Cold War. And during those 10 years after the Cold War and before 9/11, those 10 years of expansion for international law, of great multilateralism, of development of international institutions, those were fascinating days. I mean, such a huge enthusiasm for international law, for the development, for the reliance on international law. And, it's just the events of the time and the opportunities that arose. And I've been lucky to be, at that moment in time, finishing my studies and being able to get interested. Since then, of course, international law has a little bit receded, but the practice of international law continues to strive and to be more complex and more needed than ever before.
No, definitely. And thank you so much for giving this, background, and that sets a lot of context. So, I mean, I've had the opportunity and the great pleasure of meeting you about twice or thrice. I mean, I believe once you taught us at our class at The Hague and once before the Peace Palace and once at your office in Paris. And all three times in our conversations, I mean, you stressed upon one thing and one thing only, that and which comes out in introduction, is just being there at the right place at the right time. And I remember you had stressed about your PhD position, about how, you spent those 4 years and how you are, why supported, and, to have that background and, just to be dedicated to something. This brings me to a very important thing, because I remember I had a professor who's a very reputed professor of international law in India. He's called Professor Ambrose, and he in a conversation with him, he said that I do not like teaching international law to undergrad students, because they think that this is the only law that's present. Okay, so there should, according to him, there should be a bifurcation between, a person learning, or being a pupil of international law needs a certain level of maturity, which I understand it to be true. But do you think, that has been the case for you as well? That the more time you spent, and with the law, the more clarity you got on this, and that led to your decision of doing a PhD, maybe?
Well, I think it's true. I mean, it depends on academic tradition. Sometimes international law is taught at a very early stage in the curriculum, sometimes later. In Belgium, it's rather later than sooner. So you have nearly a full education in domestic law, and then you open up to private international law, public international law. But as far as I'm concerned, the ambition, the interest to write a PhD really came with the interest for the field. And when I started, the only way to specialize or to work in international law was to go through a PhD. Writing a PhD was a way to acquire knowledge, and also to somehow establish yourself by publishing a book. There were many fewer PhD at the time in all fields of law compared to today, and it was really a matter of intellectual interest. And I think you should, as a young scholar, you should only do a PhD if you really like that intellectual engagement with yourself and with your topic. With no other purpose than trying to do it as good as you can. What comes next after it, it's very difficult to see, but it's a way, of course, to specialize. It's a way to acquire a deeper understanding of the field and a better mastery of the field, and to be eventually recognized for that later on. Now, you don't need a PhD to be a good lawyer. There are thousands, millions of extremely good lawyers without PhDs. And it's not because you write a PhD that you become a better lawyer in terms of capacity to argue, etc., etc. So it's really an intellectual exercise, and it should be embraced as such. I think probably in international law, the need to do some scholarly work is more relevant, because the field is still in construction in a way, and it is a very modest way to take part into that building exercise of the legal order. Wherever you are, writing on an obscure sub-issue, but it's still one piece in a bigger jigsaw, and it may help. I wrote my PhD on war reparations. I did a long study, a long book of 900 pages in French. So it was the time of the United Nations Compensation Commission. That's why I got into the subject after the Iraq-Kuwait war and the Reparation Commission established by the Council. And that was the revival of an issue that was barely, between the Versailles Peace Treaty, First World War, and that exercise of war reparation, there was basically nothing. Actually, there had been quite a few experiments after the Second World War, but not really studied, not really understood, not really considered. So I wrote on that. And, again, this is, the circumstances of life. I had the chance later on to be involved in a war reparation case before the ICJ. And of course, what you have done academically 20 years earlier is of course something that you carry with you and that you can then use later on. But you never know how your academic work will serve later on.
Absolutely.
So I actually make a very interesting point, because I also remember during your lecture at Leiden, I think you had visited us after finishing a hearing at the ICJ. And you did mention your dissertation, your PhD even that day. And there was a very interesting connection in terms of how your PhD topic actually led you in some way to playing a very important role in that war reparations case. And I think that was the armed forces in Africa, in the Congo, in the Congo case.
That, yeah.
Yes. So I think there's also a very important connection, like you said, that being at the right place at the right time, and then how your PhD can often, translate into direct opportunities on working on very, very niche topics, reparations being one of them. So I guess for people who are, for Asians who are now looking at international law in a big way, and you said that, PhD is not always something that that plays a very important role from the practitioner's point of view. But given your own experience, would you say that before you actually start working or start thinking about practicing in that sphere of international law, you should spend some more time in scholarly pursuits, in academia, pursuing a PhD, writing more?
Well, I think it's, I will always, as an academic, I will always value research, of course, and I will always encourage young people who want to dedicate some of their years, some of their early professional years to academia. I will always, of course, encourage them to do so. And I think if you're interested, this is the time to do it. You don't do it later on. I mean, I think it's a little bit an illusion to say, okay, I'm going to practice for 5 years and then write a PhD. It's not impossible, but the circumstances of life make it sometimes very difficult because you go on with your life, and and practices might be very interesting, and you are earning money, you are spending money, you have some obligations to fulfill. And sometimes at that point, it's very difficult to withdraw from the world, as it were, and to go back in your study room and write a PhD for 3, 5 years, 6 years, 4 years. So I would definitely encourage to do and produce academic work early on in the career. I think international law it is. Probably, as I said, more of a... Of course, you can write PhDs in many fields of the law, but because, as I said, international law is still being built, a PhD in international law probably makes more sense. And it gives, in a way, more freedom of research, because the field is so vast. The approaches that you can take are so different. That it's really a field of law where research is very very adequate. Now, everything also depends on the opportunities and on the possibilities. I think if you embark on a PhD, you must accept to withdraw from the world for 3-4 years. You will see your friends evolving in life, having jobs better paid than you as a researcher, and you have to accept that. You have to accept to be with yourself, to write a book that maybe 500 people in the world will read, but it's a great privilege. It's an immense privilege to be in that position. And if you are confident enough that you can sustain that long-term effort, and it requires effort, of course. It's something that does not, it's a work. So you have to work on it every day to make progress. And if you are disciplined enough and willing and capable, sure, it's a wonderful time of a wonderful experience and a wonderful time of life, I think. And there will always be work after that. I mean, maybe not exactly what you aspire to, but there will be work. I mean, you don't stay after your PhD. You open up the possibilities, in fact.
Awesome.
So
That's great. I mean, you mentioned about we were just discussing the Congo case, and I think anybody who's studying anything preliminary, also anything to do with international law, and any comes across the charter of the International Court of Justice or the UN Charter, and while they're dealing with ICJ cases, that case comes up, in more than one issues, right? And how was it to deal with a case which had ramifications all across, the globe, and I believe that it was a bit early in your career that you dealt with this case, seemingly early in your career. So, how was it in totality, maybe?
You mentioned the arrest warrant case or the armed activity?
Yes, arrest
warrant case. Yes. Well, the arrest warrant case, it was very early on in my professional life. Indeed, I had, as a young Belgian academic, I had written several pieces on the Belgian law on universal jurisdiction. On the first, the first draft. I mean, the original law on Belgian universal jurisdiction, which was extremely far-reaching, and I had, struck a note of criticism on that law. In particular, in relation to the fact that the law pretended to exclude any form of immunity for any person accused of the crimes. And also because the law had no connecting factors whatsoever. So I had written in Belgian periodicals critical appraisals of that law. And yes, when the Congolese, the DRC government, decided to change lawyers because the case was introduced by a French lawyer, and then the Congolese wanted to change lawyer because also of the connection between Belgium being the former colonial power, the people who were in government in the DRC, who were former opponents to the preceding government. Those people, of course, had connections in Belgium, and they came to me. Many Congolese scholars and students study in Belgian universities, and they approached me and asked me whether I could work for them. And it was a real opportunity, a real privilege, and I worked on that case with two other much more senior scholars, Professor Rigaud and Monique Chemier-Gendreau. Professor Rigaud passed away since, and he was also a judge ad hoc at the court in the oil platform case for Iran. And Monique Chemier-Gendreau, she's a French academic, very well known. She had appeared before the ICJ several times. And I learned from them, of course, in the process. The case was very limited in the sense that it was a pure issue of law, whether there is immunity or not for the acting foreign affairs minister accused of grave crimes. And one issue that was finally not submitted to the court, but was discussed in the written pleadings, related to the to the far-reaching character of the Belgian law on universal jurisdiction and the conception that Belgium had of universal jurisdiction, and whether it was acceptable or not under international law, which, ties back to the issue of the Lotus case. Is there a prohibitive rule prohibiting Belgium to do what it does? The case was only decided on the immunity issue, and it was indeed it's a milestone in the building block of international law, or at least in the clarification of the law, and it was an important decision. Now, at the beginning, the DRC submitted at the beginning that the Belgian law on universal jurisdiction was as such in breach of international law, and that claim was withdrawn, and no decision by the court was made on that claim, which I think was the result of discussion within the team of counsel, and I think that was a wise decision, so that the evolution of international law would not be blocked in a way by the court, and that we would have a quick decision in favor of the DRC in relation to the immunity and the immunity only. And that I had the opportunity to present that case before the court, to plead before the court. I very much enjoyed pleading. I always enjoy pleading. I love the adrenaline and the creativity that goes with arguing, and then many years passed before I had the chance to argue another case before the ICJ. Yeah, it was a very
So I believe
experience.
So I believe patience plays. So all that, the trend that's coming out from our conversation today is that I think in the career of international law, patience plays a major
role. I know. Yeah. It might be very frustrating, and we are probably living in an era where people are impatient. But yes, you must be patient, and it's experience. It's building up experience, learning from more senior people. I mean, you must also imagine that in those cases, the governments, they entrust external counsel, and of course they want to hire those who have most experience. So in order to gain and benefit from the best advice, also in order to protect the government from criticism, because if you hire young chicks with no experience, young chickens with no experience, and then you lose, then of course you will face criticism by your national press and by other the politicians on the other side of the parliament, etc. So those cases expose the country, and it's very normal for the governments that are involved to hire, seasoned lawyers. And unfortunately, when we say seasoned lawyers, we mean people of a certain age, and therefore you need to be patient indeed when you start doing that. But the good news is that the old chaps, and I'm part of the old chaps, or nearly,
not at all.
The old chaps, they age, and of course there's a next generation, and the next generation takes over gradually, learns through the old generation, and the baton passes over from one generation to the other. But that I think that's true in many fields of professional activities. I mean, and it's normal. You learn thanks and through the more senior people, and professional maturity in a way does not arise immediately after university. It comes later on. Be patient. That's true.
So absolutely. No, so I mean, which is Yeah,
Yeah.
Paris, go ahead.
No, I was just waiting. But so, Pierre, you have more than once talked about how you started practicing in a time of changed global realities, and how, international law is still a developing field. But very often, development of any field, sort of mirrors the need of the times. So in 90s, with the end of the Cold War, the collapse of the Soviet Union, and there were corresponding changes all over the world, so international law developed in a very certain way to address those needs. Now we are almost 30 years, or more than 30 years. Uh, have you noticed any trends in terms of development of international law to reflect the modern times? Uh, in For example, the Gambia very recently brought a case against Myanmar, and they talked about genocide and how they have a right to sue even though they are not involved or it might not affect them. So there has been a continuous development, but in your view, how has that been, and how does it now international law in 2020s, for example, balance the needs of various parts of the world, various regions of the world?
Yeah. And I also believe that it's now more than ever, with the dynamics of the world seem to be seemingly fragile right now as well, right? With world powers changing here and there and so on and so forth. And I think this is not the only situation, right? We can also bring up maybe the Gaza-Palestine issue and how that's being interpreted. So yeah, I mean, and maybe you'll be able to give us an insight into how these issues have evolved across, the timeline since you have been in the practice.
Absolutely. I think the world has become much more complex, much more unpredictable, and of course also there is a much greater diversity in the international community and in the concerns of the international community. Now, the fact that the world has become more complex and more unpredictable means that the value of the law has increased, because law brings predictability. That's a legal virtue. I mean, the fact that and in a way, I mean, it's very, very strange to say, but in a way, international law pretends to write history in advance. International law gives guidance. International law says, well, if this happens, that's the consequence. Or there's a treaty that governs your behavior in certain circumstances. So law brings predictability, or should bring predictability. And in a world where, in a multipolar world of complexity, of divergence, law therefore has an increased value. In other words, it's not only, the traditions of the international community that matters. It's not only the way things are done traditionally. It's really, despite the diversity, despite the complexity, despite the unpredictability, there are some tools on which you can rely, and those are the legal tools. I think it explains the incredible increase in interstate litigation. Things have become more complex. Diplomats cannot handle everything. And they subdelegate, in a way, certain problems to the lawyers and to try to solve certain issues through litigation. And of course, because the world is more complex, because the world is more unpredictable, the relationship between states has become also more on the litigation mode. States try to vindicate some rights because some states are perceived as bullying, or some states are perceived as gravely breaching the law. And then there's an additional element, and to come to the Gambia-Myanmar case that you mentioned, and I'm acting as counsel with my colleagues for the Gambia, and I made the argument on the standing of the Gambia, the erga omnes partes argument, that despite being non-injured, the Gambia may institute a dispute and may bring that dispute to the court for a decision, and it has standing because of the nature, the character of the obligations. I think it's extremely interesting to see an African state, a state from the global south, taking seriously the obligations under an instrument that was contracted in 1948, and the Genocide Convention is the result of European history. It's the result of the Second World War, of the Shoah, and it's extremely interesting to see that you need such a small state of the global south to take seriously, as a matter of principle, because this case is really a case based on principles. There's no interest other than preserving and protecting the rule of law and the integrity of that instrument, and trying to bring to account a state which allegedly has committed genocide. We'll see if the court agrees with that claim or not. But it's interesting to see a small state from the global south taking international law seriously and sharing and being a beacon in that sense of legal fight for the rest of the international community. And it's a lesson. I mean, it's really and as you know, that case has opened up in a way many possibilities. South Africa, Israel, of course, a different case, a very different case, but again, a non-injured.
Absolutely.
You take the case on the Torture Convention against Syria. So this, and I think that we will see that more and more often, the possibility to solidify and to take international law seriously, because now enforcement of certain obligations, enforcement of certain important obligations are in the hands of every state that so wishes to. It creates a little bit more chaos in a way. But I think it will result, hopefully, in a conversation between states that will be more and more legalized, or where international law will play more and more often an important role. And when, it's not simply this old idea that international law does not exist, that international law is only for the powerful, and that it's an illusion. No, not at all. It is there. It is used to make a difference. It is not a miracle. It does not achieve miracles. It does not save the world. But it can be used to keep certain claims alive, to push for more effectiveness and for more accountability, and the fact that the capacity to hold accountable is shared between states. It gives states a great responsibility, and they can each take part in that solidification of all global common law, and I think that's very important, and it's a change. I mean, this was absolutely not the idea of the late 80s, early 90s. Not even at that moment, what was international law conceived that way. But we've seen some paradigmatic changes in the recent years. If you take the Chagos advisory opinion, this is a turning page. This is the World Court saying to the world that that colonialism still exists in Africa in the 21st century and practiced by the biggest colonial power of all time. And it's unimaginable 40 years ago, simply impossible to imagine 30 years ago. So yes, things are changing, and I think changing in the right direction. And of course, international law is under great tension because of the war in Ukraine, and but we have to fight for the legal order and for the improvement and for the keeping of that order for the future.
It's interesting you bring up Chagos, because now that we're talking about how international law has changed over the last 30 years and how states are starting to interpret or maybe look at international law in different ways, I was thinking that, the theme for this podcast is the Asian narrative, but if we were to expand it a bit, and if we were to talk about how states look at, not only states, but also the practitioners, perhaps the judges sitting at the International Court of Justice, how they look at very basic concepts of international law. Take, for example, something like the Western Sahara case, where the court had to decide whether it was an independent state. That region, did it have a standing of its own, or was it part of Morocco? Was it part of Mauritania? So at that point of time, there was a certain understanding of what sovereignty entails. Do you think with the development over the last 30 years and how non-state actors have become relevant for certain things, for consideration of certain factors, do you think our understanding of very basic concepts like sovereignty, self-determination, or the will of the people when thinking about independence, has that understanding changed, or is that understanding on a path where it is likely to change and take into consideration other relevant factors, for example, non-state actors as well?
I don't think that the basic concept have dramatically changed. I think that the number of actors interacting in the influence of international law has increased, and non-state actors, of course, are playing a big role in, major NGOs, etc., are playing a big role in the public awareness of the existence of international law and of the relevance of international law and of the need to accept, because this is a fundamental issue for each state. The key issue for the effectivity of international law is to have governments who accept external control over themselves. And, having a court of justice deciding that what your government has been doing is not in conformity with the state obligations. This is not something which is easily understood by public opinions around the world, which is easily acceptable for governments who have a very much, I'm sovereign, I don't need to be subjected to any outside form of control. And of course, you cannot have a functioning legal system, international law system, with that mentality. I mean, that mentality is alien to the very idea of international law, which is the self-submission of the state to its own obligations, accepted as such, and also to external control over the performance of the state, the way the state performed its international obligations. And I think that's, it's a matter of, there is a question, there is an issue of public opinion, generally speaking. There was a very fine piece, maybe I mentioned that already to you when I was teaching. There's the first paper published by the American Journal of International Law is a paper of 1907 published, and the writer was Elliot Root. And Root was State Secretary for the United States, a great international law lawyer. He took part in the Hague Peace Conferences, etc. And the paper is entitled "The Need for a Popular Understanding of International Law." And he makes the point that, the people, the ultimate guardians of international law is the public opinion in every country. And that the public opinion must make sure that their own government takes international law seriously and accepts external control and accepts that maybe the claims of the neighboring state or another state are not so stupid, and they could be heard, they could be decided, and maybe so there is the ultimate enforcers of international law is we the people, whether we accept or not, and whether we think that a good government is a government which is willing to submit to international law, and including to the authority of a court that could decide objectively through a collective process that could decide on certain incidents. Yeah, and I think that's not a given. And of course, the making of international law has changed also. Talking about non-governmental organizations, they are not only influential when it comes to pushing public opinion to accept or to push governments to submit to international law, to accept external control, but they are, of course, extremely influential long before. I mean, at the time of the invention of international law, what are the good ideas that need to be translated into new treaties? Who are where do those good ideas come from? Do they come from the minds of government officials, or do they come from the minds of the civil society, the organized transnational civil society that pushes government to accept certain new ideas and transform those new ideas into binding treaties that ultimately states will sign? But take the BBI, the new treaty on maritime areas beyond national and the obligations of states in the high seas. This is really also the result of transnational, international non-governmental organizations convincing governments that there is a common good in producing new rules common to states, trying to curb pollution at high seas, trying to preserve maritime diversity, etc., and prevent pollution. But the invention of the law, this moment, the invention of the law is becoming more democratic, and I think that's a wonderful thing. And it's becoming more democratic through a dialogue that goes beyond cultures and regions, and that brings the civil society together across the world. I think that's also a change from my early days in 30 years ago or 40 years ago. A great change.
It's truly fascinating, and I think I mean, what I also feel is that the nuclear arms case and the effect of non-state actors. I think there was a association of lawyers who formed which agitated the issue to be then taken up before the International Court of Justice, the nuclear advisory arms case, and I hope that more of these situations occur before the and develop the international law jurisprudence as such. But like in your last, you mentioned something about advocacy, and which is fantastic, because this takes me back to the first time I appeared before a tribunal, which was not an Indian tribunal or an Asian tribunal, and it was an Eurocentric tribunal, and the parties were not Indian. They were Middle Eastern parties. And at that point of time, I received a piece of advice from my mentor, Professor Martin Hunter, who's no longer with us. And he just told me one thing. He said, speak slow, okay? Speak slow and pace yourself. Okay? And when I look back at it, and when I got to meet him and I discussed this more in length with him, he mentioned that, when you're before people, a 3-member tribunal or a 5-member tribunal of civil law, common law jurisdictions, you prepare accordingly and you try to understand, how to argue before them. But for you, when you're before the International Court of Justice and there are people from all across the world, does advocacy change for you as such?
Speak slow is a good piece of advice before the ICJ also, because you have interpreters, and if you speak too fast, the interpreters do not follow you, and you are losing half of the court. And the president will stop you and say, please speak slower, because the interpreters cannot follow. So yes, certainly speak slowly. There is, I think, advocacy before the ICJ. The difficulty is, once you are at that stage, it's not that difficult because you have a draft to read, and your draft has of course been endorsed by the government that you represent, and it has been read by many people before you read it, and you are never interrupted before the ICJ unless you go too fast and you are asked to slow down. It's not a court where judges interrupt and and raise questions while you speak. So in a way, it's very easy, but because there is the script is written in advance. The problem is how to write the script, and that's where the real advocacy comes in. Within a limited period of time of 20, 30 minutes, you have to bring the whole argument that you have been entrusted to make by your colleagues. And of course, the work is shared. There's always a team of lawyers, and you're part of you're a building block in a bigger team. I think whether it is before a domestic court, before an arbitral tribunal, or even before the ICJ, I think a good counsel in terms of advocacy is somebody who is helping the court, somebody who will bring clarity to the judges, will help the judges see things in a certain way, in an easy... your job is to make simple what is complex, and to show, in a way, to the judges that deciding the case in your favor is more logical, easier than deciding the case in favor of the opponent. You must give them a reasoning path. You must provide them with a way forward. Unfold the case in such a way that you are helpful. A way to be helpful is to show, of course, how the arguments of the opponents are stupid and bad and should not be upheld. So there's a game there, but I think keeping in mind that counsels are there to help the court is very important, and that good advocacy is about helping the court. It's about winning for your client, of course, but it's about helping the court, and in terms of diversity before the World Court, where you have judges from all areas. Of course, they come with their own tradition and understanding of the law, but at the same time, all those people have been educated in international law. All those people went to law school, read more or less the same, they all read the same textbooks, and they've been educated, and and the approach of the International Court of Justice is fairly conservative in a way, because that's the common ground between them. It's not a court that is going to embark on revolutionary interpretation of the law. So in which it's a very specific court in a way, but it's a fairly predictable court also. And because of the diversity of the bench, what is common ground between them is pretty much black letter law and straightforward legal arguments. Of course, cases are won on the basis of the facts much more than the basis of the law. The facts are on the merits. The facts are, of course, extremely important. And, whether the judges will collectively find that the facts that you present are duly established, and whether they will recognize the existence of those facts or not is a matter of advocacy, is a matter of the capacity to persuade, the capacity to
absolutely
to have sufficient evidence and clarity in your evidence, etc. So, that's how I would conceive the role of a counsel, and to help the court to navigate the facts is very important also. In that sense, bringing clarity to their minds is very important.
Which is similar to, I believe, like you said, like any court setup.
Absolutely. And that's the trade of lawyers. That's the trade of litigators. And
absolutely.
What changes is the nature of the claims, the instrument that is invoked, the type of the obligations. And that's why I think having a domestic law experience as a litigator is always valuable. Always valuable.
Yes, absolutely. So for residents of this part of the global South, India, at least in the contemporary times, the only exposure to the to the hallowed halls of the International Court of Justice is when probably Harish Salve argued the Jadav's case, and it was streamed all across the news channels and so on and so forth. But having been at the Peace Palace, having witnessed the Peace Palace, it is a common notion in this part of the world that that international law as such is a Eurocentric concept, right? And to some extent, it might be an imposition. For example, for a nationalist government, right, it's often the thought process, right? But times are changing, I believe. In the global South, you have a few very important players coming up, and I would like to consider India to be one of them, right? So, yeah, and keeping that in mind, and the idea is that the access to the court, the access to practice is unheard of in this part of the world, right? So my question is basically bifurcated, right? What role would you think that the global South would play in the next, couple of decades as such in development of international law? And two, is much more of an advisory opinion that I would, seek for like the young lawyers in this country, is that practice is very, 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 unidirectional here, right? Do you think that practice of international law can as such maybe move from a Eurocentric approach to even the global South? When I say this, what I mean is that even when these states have disputes, okay, for example, when we go into any international disputes or so on and so forth, you have counsels from all across the world participating, okay? But often we see that the arguing counsel would be like a king's counsel or, and so on and so forth, right? Do you think it has to do with the language barrier of not maybe of English-speaking country, or the lack of participation in day-to-day international law as such, and so on and so forth?
I think you're right to underscore that. I mean, at its inception, international law is a European experiment, historically speaking. There's no doubt about that. Now, in order for international law to be truly international, the states that have come into existence since the world community has stopped being, since the world community is truly the world community with a diversity of 193 member states of the UN, it is for those states to invest in international law and to use international law and to transform. You mentioned a case where Indians never heard about the International Court of Justice until there was a case concerning India and concerning their government. And who says that their government may not use international law to its own benefit and to bring claims and use it and transform the system and make the incremental contribution of that goes with the bringing of cases, etc., etc. And of course, India is engaged in many investment state disputes, and it does stand its grounds, and of course, every case is also an opportunity for the government to develop its own administration, its own people, and there's an effort in, and that builds bureaucratic knowledge, administrative capacity, and it stays on the long term.
I think South Africa is a very good example. Sorry. I was just saying, I think South Africa is a very good example because they had an entirely domestic legal team before the ICJ in the recent dispute with Israel.
With very, John Dugard, a very well-known international law professor, has been a practitioner also for many years, and it's not because, I think you need a mixed. You need if either the state has the resources internally and can rely on its own resources and that's perfect. Or it's a very new thing for the government and will maybe be a unique thing and relies on external counsels. But it's great when the external counsels can work with local counsels also and build a complementarity between the two. And maybe the next case will be done by the government without external counsel because they have built experience internally and they have built. Now, at the same time, it's always good also to have really external counsel, people who have no fear of speaking to the government, giving the best advice, not living in the country, not relying on the government, with no fear, because you will have the best advice from people who, are not expecting any promotion, are not expecting any favor from the government later on, but and a good government is also, I think, in those difficult disputes, it's a very good thing to have an external eye, to have an external opinion, to have an expert opinion from somebody who can displease the government in a way.
An unbiased opinion.
Such, exactly. Speaking with no fear. So I think the it's the combination of both that, and some governments who are used, some Western governments who are used to litigate, they also rely on external counsels and not only on domestic counsels. That's a choice. That's a choice of how you consider things. But what is, I think, the lesson to be learned is that domestic capacity, is built by and through the engagement of the government, of the state in those cases. And so if you are never exposed to those cases, why would you need internal capacity. It is because you are exposed to those cases, because you see the value of those cases, that you build in your own administration, in your own universities, and that you gather, to the support of the state, the domestic legal capacity that will help and assist. I think that and I have worked for several governments like that. It's great to see. The part of it is helping the administration the government administration to be accustomed to what a case is, to reassure them, to help them, and to leave when the case is over. That knowledge stays domestically with the government, and that's great. I mean, that's very important. But it's a dialogue, I would say, between the external government.
And I think it's a very, very good point. It's about building experience internally as well in international litigation, is what I can conclude from them. I think this conversation can go on for hours if I don't stop myself. So I think, I am so grateful, Pierre, and the conversations with you are always a pleasure. And there's so much to take away from this.
Thank you very much.
We're truly thankful for you having you with us. And yeah, I mean, this was so short, and so we covered so many topics, I would like to believe. And
a pleasure.
Yeah, and that was the idea.
Great.
That was the idea as such. And thank you so much.
Thank you very much, Anubhav and Baras. And I hope to hear from you. Let me know when the thing is on the air.
Absolutely.
I shall do that, and I'll see you when we are in Paris or Brussels.
Yes, of course. Let me know. Always a pleasure to engage with you. Thank you so much.
Thank you so much.
Thank you. Pleasure.
Bye.
Thank you. Have a great day.
Bye.
Bye.